Hello, my name is Iamurri. I am currently a JD MBA at Tulane University and a member of the Tulane Maritime Law Journal. And I'm apparently going to continue the discourse on arbitration. My comment is entitled Marine Insurance and Arbitration Agreements, Congress's Legislated Deference to the States Defeated by the Judiciary. My comment explores many topics within it, so I will only be addressing a few key concepts here as to not bore you or introduce topics which are not readily understandable in a 10-minute presentation. With this stated, let's begin. Within the past year, in the maritime field, attention amongst the federal courts was renewed with the Ninth Circuit decision which considered the McCarran-Ferguson Act, the MFA, and the Federal Arbitration Act, the FAA. The Ninth Circuit in Galileo LLC versus AGCS Marine Insurance Company was faced with a marine insurance contract which contained an arbitration clause. The court determined that because the FAA is federal admiralty law, that the FAA preempts any state law to the contrary, namely Montana state law, which prohibits arbitration within insurance contracts, even if the state law finds support in a federal statute. And the Ninth Circuit supports its conclusion with a misreading of Wilburn Boat. The handout just applies, it's just an aid. I'll refer to it when you need to. So sorry about that. My summary of the Ninth Circuit decision helps introduce the topics which will be discussed. I'm going to discuss, regardless of whether the FAA is rightly considered federal admiralty law, does the FAA preempt the MFA? So some history. The FAA was enacted in response to judicial hostility toward arbitration agreements, and it was enacted in 1925. Within the handout is italicized the exceptions to the FAA's domestic applicability under 9 U.S.A. 2, which in short, shall be valid, irrevocable, and enforceable save upon such grounds as exist at law or in inequity for the revocation of any contract. In 1868, insurance was considered an entity to be regulated by states alone. However, in 1944, the Supreme Court revisited whether insurance can be regulated by the federal government and determined insurance is to be interstate in nature and thus falling within the purview of the Commerce Clause. Immediately thereafter, in 1945, the MFA was enacted. You can see on the handout that the MFA in 15 U.S.A. 1012B that Congress left the power to regulate the business of insurance to the states, and stated that unless a federal act specifically relates to the business of the regulation of insurance, that no interference can be conducted by the federal government. So for an analysis of what the business of insurance is, please see my comment. It explains it more thoroughly. So with this factual background in mind, let's look at why the Ninth Circuit considers the FAA to be federal admiralty law and thus not susceptible to state influence. In the handout, there is a portion of the FAA, 9 U.S.C. CA 1, in bold are words maritime transactions. These words, which I have bolded for you, led the Ninth Circuit to determine that the FAA is federal admiralty law. The Ninth Circuit supplies no evidence suggesting that the FAA should be or has been considered federal admiralty law. And from maritime transactions, the court determined that the FAA is admiralty law and thus immune to state law, even if the state law is supported by a federal enactment, namely the McCarran-Ferguson Act. So now let's look at why, regardless of whether the FAA is federal admiralty law, the MFA reverse preempts it. The MFA is a federal statute and not a state statute, and therefore is on equal footing with the FAA. Looking at the text of the MFA, we see that no act of Congress shall interfere with the state's ability to regulate the business of insurance unless the act specifically relates to the business of insurance. The part and part of the FAA states in 9 U.S.C. 1, chartered parties' bills of lading, water carriers, agreements relating to wharfage, supplies furnished vessels, or repairs to vessels, collisions. Nothing within this segment, seemingly exhaustive list to which the FAA applies, is insurance specifically mentioned. Indirectly, repairs to vessels and collisions may refer to insurance contracts, however, the requirement is specifically. And repairs to vessels could refer to repair contracts, and collisions could refer to contracts determining liability. Additionally, the MFA was enacted 20 years after the FAA, and by an ordinary interpretation, the latter statute overrides the initial enactment. Adding to the conclusion that the MFA is to reverse preempt the FAA is that the MFA specifically carves out an exception to its applicability in the Jones Act. Therefore, one can infer that had the MFA not been intended to apply in all admiralty instances, Congress would have stated so. Now, pulling from reasoning from within Wilbur and Boat, I will further my position. Initially, it must be noted that Wilbur and Boat was decided 30 years after the FAA and 10 years after the MFA, and it did not relate to arbitration with marine insurance contracts. However, it is often cited when arbitration and marine insurance are involved for the reasons I will discuss. The Supreme Court was faced with a marine insurance agreement which had been breached by the insured. The Supreme Court initially stated that there had been no federal admiralty law regulated marine insurance, and thus the court was faced with the question of whether federal courts should establish federal admiralty law in the absence of federal admiralty law. The court goes on to note and explain the history of insurance and marine insurance. As you can see on the paper provided, the court states not only courts, but Congress, insurance companies, and those insured have all acted on the assumption that states can regulate marine insurance. The Supreme Court then noted that the regulation of insurance, especially that of marine insurance, had not changed, especially considering the MFA had reinforced the state's power to regulate insurance. The measure Congress passed, this is a quote from the case, the measure Congress passed shortly thereafter, known as the McCarran-Ferguson Act, was designed to assure that existing state power to regulate insurance would continue. Accordingly, the acts contained a broad declaration of congressional policy that the continued regulation of insurance by the states is in the public interest, and that silence on the part of Congress should not be construed to impose any barrier to continued regulation of the insurance by the states. The court finalizes its conclusion that marine insurance is to be left to the states by stating that states are better equipped to handle the nuance of the regulation of insurance. As a summary, despite whether the FAA is federal admiralty law, the MFA should reverse preempt the FAA because the text of pertinent enactments dictate so, the chronology of the enacted legislation dictates so, and the reasonings contained within Wilbur vote dictate so. The tension with the courts should not exist for these reasons. Thank you. I hope you enjoyed what I had to say.